Good afternoon and welcome to this ANROWS webinar, Understanding the Role of Law and Culture in Aboriginal and Torres Strait Islander Communities in Responding to and Preventing Family Violence. My name's Heather Nantcurrow. I'm the CEO of ANROWS. I begin by acknowledging that wherever we are today listening to this webinar, we're on unceded Aboriginal land, and I pay respects to Aboriginal elders past and present, and also acknowledge emerging leaders. I also want to acknowledge that we have with us as presenters today Dr. Victoria Havain and Danella Ray, who are Aboriginal women. And Vicky and Danella, I pay respects to you and your elders past, present, and acknowledge you as leaders in the field, and particularly in the area of family violence. And thank you for your leadership and the contributions that you've made and continue to make to this important field of endeavour. I'd now like to introduce you to our panel, who are members of the research team of the project we are discussing today. So we have Dr. Harry Blagg and Dr. Victoria Havain, both of the University of Western Australia and located in Harry's office over there at UWA. And we have Dr. Tamara Tulich and Danella Ray. Dr. Tamara Tulich is also at the University of Western Australia, and Danella Ray is an independent Aboriginal researcher. Today's webinar will discuss the findings of the research project, Understanding the Role of Law and Culture in Aboriginal and Torres Strait Islander Communities in Responding to and Preventing Family Violence. The project was part of ANROWS' Aboriginal and Torres Strait Islander research stream, and we were very pleased to be able to fund this particular research project, and thank the researchers for the work that they undertook to deliver it. This is a confronting topic, and some participants may find it distressing. As with all of the work that we do here at ANROWS and the presentations we do, it's important to take care of yourself while watching this webinar. If you would like to access support, please contact 1800-RESPECT on 1800 737 732 or Lifeline on 131114 if you feel that you would benefit from making contact and seeking assistance. We're also dealing with complex ideas grounded in the evidence to be presented in this webinar. We understand that some participants may find some of the concepts challenging. We welcome thoughtful, respectful engagement on these issues following the panel discussion. Questions can be submitted throughout the webinar, and I'll put as many questions to the panel as possible. Therefore, I'll choose questions that are short and directly relevant to the discussion. I would like to invite the panel to tell us about the genesis of this research project and what key concepts the project draws on. Over to the panel.
Okay, thank you, Heather, and thank you for your welcome. I think we too would like to acknowledge that we are on the traditional lands of various Aboriginal and Torres Strait Islander nations across this country. To give you a bit of a context for the research, it's grounded in the views of Aboriginal and Torres Strait Islander women over at least the last 30 years who have been calling for a different approach to responding to family violence in our community. So in terms of the team who were involved in this project, we considered and are informed by the Aboriginal and Torres Strait Islander Women's Task Force held in Queensland, the work of Harry and Danella in terms of family violence in Indigenous communities in Western Australia, the WA Law Reform Commission's Customary Laws project that was led by Harry, and Danella also worked with Harry in that project. My own PhD research, my work during the Kimberley family which really was designed to bring community cultural perspectives into the family violence evidence space in a way that gives, in my view anyway, our law and culture its proper place. I want to say something more about the background to the research.
The project has a long genesis, really, because it is based on a succession of research projects that we have been engaged with in Western Australia and in other states, particularly the Northern Territory. And that began really back in the 1990s in the wake of the Royal Commission into Aboriginal deaths in custody. And after that, there was a kind of emerging interest in family and domestic violence in Aboriginal communities when people recognized that, you know, more Aboriginal women were being killed by their partners than were dying in custody. And it was a serious issue, and there was data that was produced by the University of Western Australia Crime Research Centre, which showed that Aboriginal women in rural and remote parts of Western Australia were about 45 times more likely to be victims of domestic and family violence than non-Aboriginal women. So that it was on the back of that we began to undertake qualitative local research in and with Aboriginal communities, particularly in the Kimberley region, that far northwest region of Western Australia. And we were alerted to the different way in which Aboriginal women talk about violence from perhaps women in the mainstream. In a number of research projects that I led with colleagues like Danella Ray and Vicky Avain and others, which found that Aboriginal people and Aboriginal women in particular in local communities had a very different perspective on violence in communities than other people do. And there was an emergingly very strong feminist based view, which was that violence was about coercive control and patriarchal power. And we found a rejection of that kind of thinking. And we're talking here in the late 1990s and early 2000s, where we met and talked with Aboriginal women and Aboriginal service providers and legal services, and saying that Aboriginal women had a different story, and that was tended to be much more about the effects of alcohol and colonisation and the kind of dispossession that Aboriginal people had experienced over the process of colonisation. So that was a very different narrative structure altogether. And we kind of followed that train through a number of projects, including a big project on Aboriginal customary law, which we did in 2000s with the West Australian Law Reform Commission, and work in the Northern Territory with Charles Darwin University. And all of these have had a very similar narrative to them, which is the kind of the view that, no, it's not just about male power. It's about issues related to trauma, the lack of control that Aboriginal people felt they had over their lives, and the victimization of men, not by mainstream structures. And you can't separate out Aboriginal family violence from those other processes and concerns. So, and that's been a kind of a general background. So we're saying in a sense that it's not a new phenomenon, you know, this looking at through an Aboriginal lens has been going on for some 25 or so years in research, but it's rarely been picked up by the mainstream, which has tended to rely heavily on research on domestic violence from the United States and from Western Europe, and solutions which are based in using more of the criminal justice system. A criminal justice system, we add, that has done a lot to dispossess Aboriginal people, and not something that Aboriginal people place a lot of faith or confidence in. So we took that kind of thinking, which is about colonisation, trauma, the effects of alcohol, drugs, the general sense of frustration and rage that many Aboriginal people have, we took that into work we did for a report that came out in 2018, which was written for ANROWS on innovative models for addressing family violence in Aboriginal communities. And that was, I'm sorry, I've just press-ed that title because it's quite a long one. And that was again done with Aboriginal field workers and in partnership with Aboriginal organisations in Cherbourg, Darwin, parts of the Kimberley, and including Fitzroy Crossing, which was an important site for innovation at that time. And I think, again, it confirmed previous work that Aboriginal women and Aboriginal women's organisation were frustrated by the kind of structures that were being applied by state government domestic violence services. There wasn't they weren't comfortable with mainstream, particularly white managed and run refuges. They didn't think restraining orders worked for them terribly well. And they felt that the policies that had been enacted nationally actually did more to break up Aboriginal families than heal them. So there was also this kind of like powerful drive from the grassroots for an approach which was based much more about healing, about involving men rather than simply just marginalizing them as perpetrators and so on. So we brought that kind of that logic and that thinking into this report. And, you know, that is informed by work that the Law Reform Commission of Western Australia did back in the 2000s, which developed a specifically Aboriginal approach to family violence, which is local, community-owned and managed, and place-based. And it tried to employ different strategies like taking people on country, bringing families together and so on, and which is very much at odds, I think, with the kind of mainstream approach. And we're not denying that that approach isn't sometimes necessary, or that there aren't elements around things like coercive control and so on, but there's a broader picture that needs to be addressed, which is not taken into account in things like the Duluth model and so on.
Okay, thank you both for that. Yes, I do recall, just drawing back to your points, Vicky, about the 30 years or so of advocacy from Aboriginal and Torres Strait Islander women. Before I go into that, actually, I do want to say I hadn't acknowledged the Torres Strait Islander people, so I want to do that as well. Of course, you know, here in Sydney, where I am, I'm on Aboriginal land, the land of the Gadigal people of the Eora Nation. But of course, there are people joining from all over the country, and we reach out to the whole country. So yes, it absolutely should acknowledge Aboriginal and Torres Strait Islander people's elders, past and present, and emerging leaders. But yes, Vicky, the report of the Aboriginal and Torres Strait Islander Women's Task Force on Violence of 2000 was released in 1999 and released again in a second edition in 2000. And that report was incredibly important and groundbreaking in terms of the advocacy from Aboriginal and Torres Strait Islander women in particular about how they saw the importance of innovation and support for their work and alternatives to the mainstream responses to family violence in Aboriginal and Torres Strait Islander communities. So this research points out the way in which the mainstream legal system in particular rejects the incorporation of traditional law and culture. Can you tell us more about that?
Of course, thank you, Heather. I just want to begin by acknowledging that we're speaking to you today from Noongar Budja, the unceded land of the Whadjuk people of the Noongar Nation, and I acknowledge the traditional custodians of the land on which we live and work, and recognise the strength, resilience, capacity and continuing culture and contribution of the Noongar people. I'd also like to acknowledge that I'm talking today with all of the privileges afforded a white woman in this country. As a lawyer, I see the white law and the mainstream legal system as my responsibility, and that's what I will talk to when I talk about how the mainstream legal system has responded to Aboriginal and Torres Strait Islander law and culture. And this is obviously an enormous topic, so I'd just like to make three quick points today that have arisen from our research. First of all, any discussion of the recognition of Aboriginal and Torres Strait Islander law by the mainstream legal system needs to acknowledge the long history of resistance of Aboriginal and Torres Strait Islander people to the jurisdiction of mainstream law and to white sovereignty, and that the recognition of Aboriginal and Torres Strait Islander law within the mainstream legal system remains a point of contestation and resistance. Secondly, the mainstream legal system has resisted the formal recognition of Aboriginal and Torres Strait Islander laws, and in particular criminal laws. So many in the audience will be aware of the 1994 High Court case of Walker, in which Chief Justice Mason explained that Aboriginal law, should it have survived British invasion and colonisation, was extinguished by the passage of criminal laws of general application. And His Honour said, English law did not and Australian criminal law does not accommodate an alternative body of law operating alongside it. There have, however, been attempts to accommodate Aboriginal and Torres Strait Islander law within the mainstream legal system. And this has happened where mechanisms already exist for this type of accommodation. And we've seen this, for example, through sentencing, where judges exercise discretion under sentencing legislation to exercise their discretion to take into account all relevant factors. So what we've seen over the last 100 years is a number of examples of, particularly in the 70s, 80s and 90s, of courts taking into account the views of community members, including as to law and culture, and also taking into account traditional punishment as a mitigating factor on sentence. However, there is also a strain in the case law, and increasingly of late, in which judgments have not recognised the strength of law and culture, and where the courts have not taken into account the views of the community, and where the courts have expressed condemnation for Aboriginal punishment. And this leads me to the third point. So it's not so much a question of the mainstream legal system's rejection of law and culture, but of the way in which law and culture have been accommodated within the mainstream legal system has meant that the mainstream legal system is the one that speaks for Aboriginal law and culture. So the mainstream legal system maintains its privileged position as the mechanism through which Aboriginal and Torres Strait Islander law and culture are defined, proven, and evaluated. So the content of Aboriginal and Torres Strait Islander law and culture is determined according to the mainstream legal system's principles and processes, so according to the laws of evidence, and assessed against Western notions of punishment and responsibility. And these sites of accommodation can also be taken away. And we've seen this happen in relation to that sentencing discretion at the federal level in 2006, where under reforms to the federal sentencing law, we've now seen a prohibition on courts taking into account cultural, any form of customary law or cultural practice as a mitigating or aggravating factor on sentence. And this was extended to the Northern Territory by virtue of Commonwealth law as part of the Northern Territory intervention. So what we're left with, as many Aboriginal and Torres Strait Islander researchers and non-Indigenous researchers have pointed out, is a mainstream legal system that remains the dominant partner in the relationship, that speaks for Aboriginal and Torres Strait Islander law and culture and determines when it can be taken into account. And what this does is simply reinforce and replicate the settler colonial project.
Thanks, Tamara. That was those 3 points were, very enlightening for me, and I'm sure for many others in the audience. And thanks for being so succinct and comprehensive at the same time in taking us through that, because there are some complexities there as well. For many people, the concept of traditional law and culture conjures up images of harsh physical punishment, and yet this research is advocating for the use of law and culture to respond to family violence. Talk us through what the evidence has to say about this.
So I think what a key message that we want to convey from our research is that communities are asking for very clearly to be able to use law and culture to prevent violence, family violence, or to inform early intervention. And in saying that, there are a range of options that are available in law and culture. So you're right. Often, you know, people will think when we talk about law and culture, we're talking about spearing people. That's not necessarily what communities are asking for. I think it's also important that the audience understands that, you know, what we're talking about when we're talking about law and culture. And I draw on the descriptions provided by Kimberley Aboriginal Law and Culture Centre in how they describe those concepts of what law and culture is. So for them, they talk about the law and culture being stable and enduring. It's the unchanging legacy of creative ancestors who formed the world in the Dreamtime and established the all-encompassing moral and practical rules by which succeeding generations of Aboriginal people have lived for thousands of years. They also talk about culture as being subject to change, so our communities know and understand that you know, we're under considerable pressure from Western society, which is having an impact on how we practice our culture. So the way that Kimberley Aboriginal Law and Culture Centre think about it is that culture describes the way in which people apply law every day. So with that in mind, that communities in our research are asking for the space in which to utilise law and culture to try to prevent family violence, but also to intervene early. And I think my colleague Danella will speak a bit more about some of the examples. I might just address the issue of physical punishment. And just to say that, and I don't want to sort of harp on it and dwell on it too much, because that's not, if you like, the extent of what people are talking about when they refer to law and culture. So I just want to make the point that physical punishment is different to generalised violence. It's qualitatively different. It is structured, purposeful, time limited and measured. It's located and carried out within a law and culture kind of context and structure. And generally, in communities where this is sort of carried out in response to generally very serious transgressions, every member of the communities know that this could be a consequence for them if they behave badly and cause harm in the communities. So I didn't want to sort of dwell too much on it, because that's just one aspect of the range of options that are available to communities in through law and culture in response to, you know, a range of behaviours that the communities might want to sanction. And so it can range from, you know, growling at a person that has not done the right thing, through to, you know, elders getting involved. It could be that, you know, people are banned from certain activities like playing on the football team, you know, being banished from the community, right through to the serious or kind of severe end of the spectrum of responses that are available in law and culture, which might be about physical punishment. So it doesn't happen all the time. It is available though for very serious matters, but I suppose we really want to emphasise that through our research, people talked about the range of options that are available in law and culture. So yeah. I would encourage you not to sort of think about, you know, automatically think that law and culture means spearing people, because that's actually not correct.
Yeah, I might add to that. I mean, we found in our consultation project, Morning Island, for example, when we went there, they wanted to use a particular island that's close by to them as a place to take offenders, people who misbehave on the community, maybe take the whole family if necessary. And that kind of thinking of using outstations and country as an alternative were we tended to find, talking to people, that, and this again confirmed what we'd heard in the Law Reform Commission in the 2000s, was that increasingly Aboriginal communities would be leaving very serious, far more serious cases involving violence, were much more comfortable with leaving that to the mainstream system. And I think that's happening more and more. But I think it's really also important to stress that our system of criminal justice is itself irrational. It's based upon violence in terms of using long periods of incapacitation and incarceration. The violence in our system, it might be a different sort of violence, but it still is based upon a very kind of punitive approach. And it doesn't work. And I think one of the clear messages from many years of research around Aboriginal justice is that the mainstream justice system doesn't provide a deterrent for Aboriginal offenders, and that it's often irrelevant to resolving the underlying issues that constantly lead to violence in communities. And so we think that our system needs to be decentered a little bit, and there should be more scope for engagement with Aboriginal alternatives.
Thanks very much for that. And yes, that the point that you're making there, Harry, about the legitimacy of law, or how it's seen by Aboriginal and Torres Strait Islander people, and you know, certainly that's something that's come up in your research, but also in my research in regard to the compliance with domestic and family violence protection orders in Queensland, where for many Aboriginal and Torres Strait Islander people being, you know, continuing to rotate through the criminal justice system, the criminal legal system, it was really a consequence of their not recognising the orders because that the mainstream law had no legitimacy in their lives and no relevance. So it's an interesting point, and one that I think we'll continue to challenge with for some time. But it's certainly an interesting point that you've made there, and Vicky, thanks also for you know, the explanation about the range of options that are available in traditional customary law and culture. For, you know, an example you gave, Harry, of you know, the people from Mornington Island wanting to use, you know, maybe taking a whole family to another. That's probably not going to be an option for family violence, but of course for other in other situations it might be. And you know, I mean, it kind of feels from a Western perspective punishing the whole family, but you know, I think that's the point, is that we, you know, as a white woman, you know, I need to be challenged about when putting my lens and my perspective onto an Aboriginal perspective. And we have been for many years, as we spoke about earlier, the Aboriginal and Torres Strait Islander Women's Task Force on Violence, asking us, almost pleading with us to stop imposing and start listening and seeing things from an Aboriginal and Torres Strait Islander perspective.
You can't underestimate how alienated Aboriginal people feel from those kind of mainstream systems. And, you know, they see, when we talk to people who've said, you know, that the children's child protection system, the family violence system, the criminal justice system are all there to break up families. That's what they do. Maybe not the intention, but the outcome is that it's constantly breaking up Aboriginal family life. And they see the solution in much more in terms of, let's heal family, let's bring family together. And we're talking here about wide set of notions of family, where uncles have a role, and cousins have a role, and aunties have a role, and elders particularly have a role. And that's a very radical departure from the way that we do justice. But we've got to find a way to listen to that more.
Yeah.
That, you know, while we're talking about you know, law and culture and punishment and so on, communities are really clear in offering as well, as part of the conversation, that there are solutions and resources that are available. One of the communities, I think we've spoken about this before, but one of the communities we worked with, they use women's law to help to create safety for women who use the safe house. And so their way of doing that is to, you know, they have women law bosses who sit on their board of management, and they store some women's ceremonial items in a lot at the refuge. So everyone in town knows, again, the woman thing's there, don't go there. And so, you know, we are willing, and communities are willing to use the resources that are available to them. It costs governments nothing, and it's an innovative way, when you're looking through Western eyes, that communities are utilising the resources that they have at their disposal. So as a result, you know, they don't need to have big, you know, 6-foot or higher fences and complex security systems, because they're utilising women's law and like the belief system and spirituality to actually help create safety in the community. And we have other examples, Harry, that you mentioned from other work where women have advocated for and actually have been the location of women's safe houses on women's country. So it's not just advocating for or sharing out the results of our research in relation to law and culture. It's not just about it's also about recognizing the resources that are available to
Yeah, thank you, Vicky. We might move on to the discussion of move a bit forward into it. The research found that healing from trauma is necessary to address family violence, and that healing is best done on country. It would be helpful to unpack that a bit for us. We're wondering whether you might, Janella, be able to share with us more about what that means, and you know, help us understand it from an Indigenous perspective.
Thanks for that question, Heather. And firstly, I also wanted to acknowledge the traditional owners of the country that we're actually meeting on today too, and all the TOs and across Western Australia and the nation. I also just wanted to acknowledge and thank all of those Aboriginal participants who took part in the research. Over the course of the consultation process, the research team actually met some really wonderful people, both men and women, and we really valued their contribution actually into this project, and they certainly provided us with some great insight and stories into their culture and some many interesting yarning sessions. So I particularly also wanted to thank the elders at Tiwi, both Terry and Torres at Tiwi, who run the cultural camps, and for sharing their knowledge and cultural insights and wisdom around possible solutions and issues associated with this complex problem. I also want to thank the Matu group and those that actually participated, the Kimberley group for their valuable input and some interesting discussions there. I also wanted to thank the women actually in Darwin who also participated in the yarning sessions we had there, because those women actually came from right across the Northern Territory. So they had insights that came with various communities as well too. And although I didn't actually attend Mornington Island, I still want to acknowledge them and actually say thank you very much for the input from them. So the question around healing and why the healing programs should be delivered in on country, in order to actually understand this, why we should actually have it on country and healing, and any of these services that we're delivering on country, I think we need to actually understand the issues actually from an Aboriginal perspective, and some of the factors that's actually influencing this. So why the location? In order to actually answer this question, it's important to understand how Aboriginal culture and societies and how they actually function. And hopefully I can actually represent them and their views and give justice to their input and credit for those people that actually were talking about this and the necessity to actually have this on country. So it's not actually a lesson in anthropology, but I'm just trying to give a brief snapshot of culture from an Aboriginal lens and an Aboriginal person's perspective, and those people that actually contributed to this project. So I hope I can convey their stories in a way that's respectful and actually gives justice that it actually deserves. So firstly, if we actually look at this history, we look at Aboriginal occupation and connection to this continent and the relationship to this country, it's an incredibly long one. So Aboriginal occupation and connection into this country is estimated to be approximately 60,000 years. Some anthropologists or archaeologists are actually indicating that it could possibly be more. So this idea of actually connection to country and to land is actually considerably old. The land itself is actually central. People are actually saying, you know, the land itself is central to our culture, and it gives us this notion of place and country, this connection and the environment. It's actually intertwined in this elaborate system of physical and spiritual connection to the land and their environment. So if we look at the Dreamtime stories, for example, and there's lots and lots of Dreamtime stories where people actually talk about their connection and looking at it through the lens of Aboriginal people. Some people actually refer to this as Aboriginal mythology. In any event, there's stacks and stacks of Aboriginal Dreamtime stories or creation stories that relate back to the beginning of time, where Aboriginal people actually believe the continent was being formed and through ancestral beings. So these Dreamtime stories, we can actually see Aboriginal people believe that these, through these Dreamtime stories, these ancestral beings and coming actually out of the ground and the sky and through the animals played an important role actually in this creation into this continent. So these stories are actually founded in different Aboriginal language groups right across the continent. So each group will obviously have their own stories. If you look at it, we actually have roughly about, I think it's roughly about 300 different language groups, I think, across the country with approximately 650 different dialects. So some of the examples of these, and one of the particular ones that I wanted to refer to, which I think actually the Yolngu group actually gives some interesting stories, but also the book actually within the Kimberley is a good one too, The Yora Yora Spirit of the Kimberley by David Mawaljali, where you actually have Aboriginal spirituality actually being compared to Greek mythology. And while it actually offers some interesting insights, I think there's a little bit of criticism actually around some of this stuff. But the main point is that it actually points out this whole notion about Aboriginal spirituality and the connection to country. So if we look at these Dreamtime stories also is that, and the stories of creation, I mean, there are ceremonies that obviously connect and interconnect into these things. There's stories and ceremonies involving men. There's stories that actually involve women and women only. And some of these stories actually involve both men and women, and some actually involve men, women and children. So not just the stories, sorry, but the ceremonies as well that actually go with it. So the role that individuals play in these ceremonies also is very interconnected actually into this notion of spirituality and through the moiety. And this has largely been misunderstood actually over the last 200 years for various reasons, but it's a very complex system. And an example of this of where the Western legal system recognises Aboriginal people's culture and connection to land and place is best understood and can be found within native title cases where Aboriginal people provide oral testimony and stories connecting them to country or land. And this is done with the assistance, obviously, of Gadiya or Bullanda anthropologists, white anthropologists, to translate these stories into a format for the Western legal system to understand and acknowledge. And it also should be noted that we've got a large number of the native title cases actually being resolved across Australia too. So, so we've got this, we've got the stories, we've got them actually being translated through the white anthropologist actually into the system. So it's well known. It's it talks about, you know, how Aboriginal people are connected to country. you know, and those connections actually through this patrilineal and matrilineal systems. But it's also fundamental that we actually understand this also around the Aboriginal native title and the relationship to land is that is around this notion of ownership. But Aboriginal people are considered, their connection with land is that they're the custodians and they have a responsibility to look after the country, because if they look after country, country will look after them. So this is really, really important to actually understand this, because when people are actually talking about connection to country, people are very passionate about this responsibility that they actually have. And it's a reciprocal sort of thing, is because if we're actually looking after the country will actually look after us. So unfortunately, because in more contemporary times, as we actually know, is that through past government policies, Aboriginal people have been taken away from country, they've been taken away from their family, they've been placed in missions and reserves, and the legacy of this is still being felt today. So the emotional impact and experience has been devastating on Aboriginal families and generations of family ever since. There's been some of the impacts is obviously loss of language, sense of identity and who they actually are. So, and how they actually fit into the community and how these things within contemporary societies are actually being dealt with today. So there's a lot of unresolved issues and as a consequence of these impacts of colonisation. So if we look at it, some of the things that are actually happening today is obviously people are reconnecting to culture, and people are going back and learning language, and through learning language they're learning the stories and then the connection back into country, because that essentially is actually about the identity and their cultural identity. So some of these ideas about this one size actually fits all doesn't necessarily actually work. Various groups that we actually consulted with through this project stress that any healing or conflict resolution or mediation process, it must actually occur on country. This is where people have their spiritual roots. This is where they need to heal. This is where they have the need to reconnect. When we're actually doing the consultations as to who those groups might actually be and how their systems actually work, because each group, each language group will be different, and their stories will obviously be slightly different. So I guess so from that point of view is that the main thing to actually say is that the land actually underpins our spirituality as well as the kinship and the community, and it defines the Aboriginal community and who they actually are. It determines the language groups, it determines the identity of individuals and who they are. They usually make reference to their identity by referring to the language group and their geographical location. So this really is at the centre of their concept of who they are and their identity. So the consultation process, I think, made it very clear that people were saying, you know, they want people to come and they want people to actually listen and hear what they're actually saying. And they said that it's not just about coming and actually hearing what they've actually got to say, but actually really listening to what they've actually said.
Yeah, thanks. Thanks so much, Danella. I think, Vicky, you wanted to come in?
Just very, very quickly to build on what Danella was saying. So in terms of trauma and intergenerational trauma, if you like, the concept of what that constitutes must come from our people. And as a wise woman said to me once, it contains or must include the story about how we lost our right to our country, lost our right to our language, to our ceremonies, to our family, to be able to practice our culture. You know, all of those elements or events that have resulted in our people experiencing what we call intergenerational trauma. And by understanding that, we can see where, if you like, the points for healing might lay. And so if it's about enforcing culture and law, if it's about, you know, responses that support, you know, how our families function and our ways of parenting and looking after and growing up our children, you know, there's a whole range of ways that we can work on healing in response to that kind of idea of trauma. And as Danella mentioned, you know, spirituality is inextricably linked to country. So, you know, very clearly, you know, people talk about the importance of doing some of this healing work on country, because that's where, you know, we get our spiritual healing as well. Thank you.
Thank you. Thanks, Vicky, and thank you both for taking us through that really key concept and important aspect of this work around healing from trauma and the central role that country has to play in that. And I recall the model that the team members of this team in previous research for ANROWS developed, the country-centred model of response, and you know, that model still sits in my mind about the centrality of country and the you know, the kinds of strategies that sit in the liminal space, and then the mainstream responses that in the outer rim of that model. So thanks, Tags. And Danella, I want to thank you for bringing in the participants of the research into the discussion and remembering, recalling and recognising the contribution. I mean, this research wouldn't be possible, of course, without those participants. So, I really felt connected to that work and those people in the way that you brought them into the discussion today. So thank you for that. And we do want to go, you know, we've unpacked one of the key concepts around healing from trauma that is really central to this work. But another very important concept is the importance of whole of family responses. And you know, we're keen to hear from you about why it is, from your perspective, that men and women work together to develop solutions to family violence. When, regardless of whether it's Indigenous or non-Indigenous, it's predominantly men perpetrating violence against women, and the impacts of that on children. So can you talk us through a bit more around that, please, Danella?
Thanks, Heather. Yeah. So in terms of actually unpacking this a bit more, if we can actually just look at culture sort of in a broad sense too, is that we not only have these Dreamtime stories and this Aboriginal spirituality, but the other aspects of Aboriginal culture is this thing around kin or kinship, moiety, and these totems. So in order to actually understand this, if we look at it sort of collectively, this actually sets the rules and values around these relationships and these cultural protocols and how community actually interacts with each other and the environment. It sets out rules around who you can marry, who you consider to be your siblings, and what your roles and responsibilities are. So we need to actually understand a little bit about this. We're not expecting everybody to be anthropologists, but in terms of actually how these communities actually function and how they, because for a lot of them, law, Aboriginal cultural ways of doing things and law and culture is still very strong, and they live this every day. So, and these are very interconnected, but actually having said that too, is that we actually need to be mindful is that each group is actually very different. So these components really are the glue and the fabric that actually bind people together within the Aboriginal community. It also determines things like family structure and what that family structure might actually look like, which is actually very different to non-Aboriginal Western ways of actually looking at things. So it's very different to the Western notions of family and how people actually come together. So the notion of families and families according to Western families and notions of family and the structures are very different to Aboriginal notions of family. within Aboriginal communities, the family and concept of family and the structures within those communities are based on the kinship system. People within Western families generally refer to mother, father and siblings or children. Under Aboriginal systems is that there's not just mother and father and siblings, but there's also the extended family arrangement and relationships that people actually have with the extended family arrangement. And uncles taking on a different sort of role than they would normally under the non-Aboriginal systems of family, and roles of grandparents, particularly with grandmothers and grandfathers, and how they interrelate to grandchildren. So relationships and the responsibility of relationships, how people come together, there's a much broader and extended family relationships, and these come back to the responsibilities again, and the rules around those relationships are interconnected into the kinship system. So how I actually relate to my cousin or my grandmother will be very different to how people will relate under the Western non-Aboriginal system of families. Within those systems also is the roles and responsibilities of males and roles and responsibilities of females. And then there'll be some responsibilities associated with both male and females. So while concepts of family under the Western system generally refer to mother, father, children, under Aboriginal ways of relating and interrelating is very different. So, and there's extended relationship arrangements. There are a number of resources available, and we'll get ANROWS to send them out if people are actually interested. One particular model that people may be interested in actually having a closer look at is the model that actually operates on Tiwi Island, and this is the model, the Ponki model, that the people within Tiwi wanted us to promote for people to have a look at. This model was actually developed based on these cultural ways of actually working. It's a group that were actually brought together. It involves men and women actually within the various skin groups, and these individuals, and it consists of elders or the acknowledged elders or recognised leaders within these various skin groups. And by actually bringing these people together on this Ponki group, their focus is actually through mediation and conflict resolution and promoting leadership actually within their communities. So one of the, I was going to actually give a quote actually from one of the women, but I see that we're actually running out of time. So what I'll do is I'll just leave it at that and say that we wanted to promote the Ponki model and how the Ponki model actually works with the community in actually trying to use the cultural culture and aspects of culture to promote conflict resolution and mediation within the Tiwi community. So the kinship system is not just about setting the rules around the relationships, but it's also a factor that's actually influencing behaviour and the behaviour actually within the community.
Thanks, Donella. Look, there's so much to be seen,
Yes.
and you know, it's a shame we haven't got that quote. We only have a few minutes left now, so I will move to a couple of questions. I'm going to the first one I'll ask is I think that you've answered some aspects of it, but perhaps just focus on the middle. But the first question is, what is the current significance of law post-colonisation? I think we've addressed that part of the question. Why is it so secretive? So, I think that's an interesting question from the participants. And is there an equivalent for women? Again, Vicky, I think you may feel that you've answered some aspects of this, but if there's something that you wanted to say in response to that three-part question.
Thanks, Heather. If you like, traditional forms of law is still practiced, and certainly in our research, there is an equivalent for women. So we do have women law bosses. I'm not sure that the term secretive is the correct word to use in this context. And I suppose, I was sort of thinking about it, and it may be that, if I think about it in a Western sense, so you've got doctors who are experts in medicine, you've got lawyers who are experts in the law, you've got like psychologists like me who have some expertise around counselling and that sort of thing. So as one of the women elders in one of the communities said, that our elders have what she called like different portfolios and responsibilities. And so one way of thinking about it is that, you've got, our law bosses who are responsible for holding and carrying the law forward, teaching, if you like, the next generation of people who are going to carry the law forward. I'm not sure, I'm sort of a bit uncomfortable with the term secretive. I know it may seem that way, and it may be that there are some sacred things or elements of law that are known or are to be known only by certain certain members of the community who happen to be law bosses. Similarly, we have our other roles within law and culture that the people responsible for those roles or who carry out those roles have or hold sacred knowledge and carry it forward.
Thanks for that. Look, there is. I think this is a question that's probably on a lot of people's minds. So I might go to this one. It's is there evidence that traditional role of law and culture is more relevant in regional and remote communities compared to urban communities? So, your research has focused, I suppose, in more remote areas of the country. So, what can we learn from your research, if anything? And obviously any research can't be all things, but what would you say about your research in regard to relevance to urban settings compared to rural and remote?
Well, we've had that conversation as we've been around, and I think we introduced our talk by saying that we wanted to look at communities where there was that unbroken connection with traditional law. That's why we chose kind of Northern Australia. But we're also aware that there is law and culture in urban and rural parts of Australia as well. We sit on Noongar Boodja here in Western Australia, and there's a powerful set of stories around, just where we're sitting at the moment in the Durbil Yerrigan, the Swan River there, and there's a very strong connection to culture and country down here. And I think law and culture are practiced particularly through responsibilities and obligation to kin. If you look at how families are structured and so on, it's stronger here to Aboriginal notions of reciprocal care and support and so on. So we don't think it's an exclusive project in that respect. And we know that that there's I think, a growing interest in the southern part of Australia using Aboriginal culture And that's reflected in things like Aboriginal courts, which are very strong in Melbourne, increasingly in New South Wales as well, and using community justice mechanisms which involve Aboriginal elders and leaders. But we don't think it's a case of it's just law at the top of Australia and no law at the bottom, and we're not trying to say that at all.
Yeah, and your research. Sorry, Vicky, you go, please.
And so, to add to what Harry said, you know, if we kind of look at it through the lens of what our law bosses up in the Kimberley say, you know, or how they describe law, for instance, they use the kind of language or description to say it refers to the all-encompassing moral and practical rules that Aboriginal people live by. And so that still exists, you know, here on Noongar Boodja. It talks about, or law includes dreaming stories that contain moral and spiritual rules that govern how we interact with each other to make sure that we are also, you know, as I say, like ensuring that harmony exists between living things and the country. So if you're going to look at it through that lens, you can see that it exists across this country, and it doesn't just reside, if you like, or exist in Northern Australia. So I think it comes back to what we're saying earlier too, that law and culture isn't just about, if you like, living traditionally. I think those fundamentals, like, you know, morals and rules, that sense of, you know, harmony, ensuring that we are looking after country, dreaming stories, which are all part of law and culture, that exists across the country. It might look a bit different in different locations, and that's okay because we're diverse peoples. But as Harry sort of mentioned, you know, we see evidence of law and culture here, where we are in a big metropolitan city. So, yeah.
Thanks, Vicky. Unfortunately, we are going to have to stop it there. I mean, it's a conversation that I'd like to continue, but we're out of time. But I do want to thank the panel most sincerely for your time, for the research that you've done, the contribution you've made and will continue to make to responding to and addressing family violence. I really appreciate all of that. And finally, a reminder that the research report and the research to policy and practice paper of the project discussed in today's webinar is available on the ANROWS website. So thank you one and all presenters, and thank you to the audience for your participation. We appreciate it. I'm Heather Nankaro on behalf of ANROWS. Good afternoon.